Well, good afternoon, ladies and gentlemen. We have a very interesting show today, I think. I try very hard every week to come up with something a little unique, something a little different to distinguish us from other shows that are on the air. I've been doing some podcasts for people, and you can see they have general themes. Our theme changes every week. And so if you don't listen to all the shows, we try to catch up with some of them and give you some new things at the same time. So today we're going to do two things. First, I'm going to talk to you about defamation, because we have been talking about free speech versus government restraint, restraining orders, and all that. So what happens if somebody does say something that's not so complimentary to you? What rights do you have? What do you need to prove? What are the elements of defamation? What are the defenses, if there are any? We'll just go through some of the basics, and we'll talk about that. And the second part is even more unique, because you're going to hear a real case.
Cool.
Not a real case theoretically. We got the tape.
Yes, we do.
Here's what happened. In the courts that I sit without a court reporter, which is most of the courts, there is a tape recording made of every case. And that's to protect the record in case there's an appeal, things of that nature. So there's a recording. And not too long ago, actually about 6 months ago, I guess it is, I took a case under submission, meaning that I wasn't making the decision from the bench. I wanted to think about it. There were some unique issues, and I wanted to kind of finalize it after I had a chance to think about it. And so I got a call from my clerk, said, you took it under submission. It's been a couple of weeks, and the parties showed up, and we need to get a decision from you. So you need to write an opinion, or so I can prepare what's called a minute order. I said, okay, the problem is I had like 25 cases that day, and I don't remember all the facts. And frankly, I don't want to make that admission. No, I had remembered some basic issues,
well,
but
Judge,
I didn't know all of it.
25 cases. I can't remember. Can't remember every
That's
case.
Right. But I wanted to be thorough and be sure, so I wouldn't make a decision based on some erroneous fact or something that I had mistaken or had forgotten. So I said, okay, I'll tell you what. Send me the recording. I'll listen to the recording. She said, well, there were two appearances. The first one was the actual trial, and that, by the way, lasts 8 minutes.
That's a small claims case.
Yes, it's a small claims case, and it's in Ventura County, in Department 36, where I was sitting regularly. And the second one was 30 days later, approximately 30 days later, when I had continued that case for another appearance. So that one lasts only 3 minutes, as you'll see. So this is the real deal. This is the voices that you hear are the litigant, actually, because the defendant did not appear. And you could kind of hear in the background my judicial assistant. We used to call them clerks, law clerks, and they know far more than we do. And in fact, one time I made a comment that a party could appeal a ruling, and the clerk kind of stood up a little bit and leaned over and started to talk to me. And she says, "You can't do that."
Oh, really?
I said, "Really?" She says, "They don't have a right of appeal under these circumstances." I didn't know that. I mean, I read the book. I've been certified, I think, 3 times in small claims court. Every 3 years, you have to be recertified. So I was pretty much up to date. I thought I knew pretty much everything. It proved to me I didn't know everything.
Well,
they know more than we do.
The clerks do.
They absolutely do.
They should be the judge.
They make us look so much smarter. Because I can remember having conversations, post-hearing with some of the court personnel, and I would say something, and she would comment. I said, you know what? That really makes a lot of sense. So she had a lot of input in making that decision.
Would a clerk influence your decision on anything?
Actually, it did. Not influencing me in a negative way, but providing me with facts that I hadn't thought about.
More information.
Information, right. And they do all the paperwork. You can say ABC. The next thing you know, they do it all. They prepare what's called a minute order for every single case. So there's a record in the file as to what happened, who was there, who appeared, what the result was, that nature. And
like an index.
Yeah, and sometimes I would write an opinion. And they would prepare the opinion, type it up, send it out, and do all of that. In the complicated cases, and I had a bunch of complicated cases, one of which I mentioned was to determine the constitutionality of a statute. For that one, we did a lot of independent research, and I actually wrote an opinion to support the conclusion that I had reached. It wasn't the one I wanted to reach.
Oh, it's
I really wanted to go in one direction, but I couldn't. We found case law and authority that would be totally contrary, and I didn't want to be appealed, and I also wanted to be right.
And neither did Robert Mueller.
I don't think I want to get into that one. That one could generate a dialogue that could last for a long period of time.
It will last for a long period of time. It will.
I don't think this is when it's going away. These people are determined, one side to do damage to the other, and the others are going to fight back vociferously. But every day in the news, we get something new. Like I see Avenatti got arrested today.
Yes, he did.
I can't believe that, how stupid somebody could be. I don't know enough about the facts to come to any conclusion, of course, only what I hear on the radio.
Do you think he regrets putting his name, because nobody even heard of Michael Avenatti before the Stormy Daniels thing. Do you think he regrets putting his name out there and becoming a celebrity now? Or
I don't know him, so I can't judge what his
character, his
personality is. But I understand that a colleague of mine, who I know, is an unindicted co-conspirator.
Who's that?
I don't really want to.
Oh, come on.
No, I really don't want to do that.
It's in the news.
It's definitely in the news.
Okay.
I think I found out.
Well, can I say the name?
And I said, you can say. Of course
Mark Garagos.
Yeah. that I can't believe.
Wow.
Because Mark is successful. And he doesn't, from what I can tell, he doesn't need the money. Avenatti needed the money. He had a $10 million judgment against him. He was trying to raise the bucks to pay for it. I don't know whether he did it or didn't do, and I don't come to conclusions. There is a presumption in the law, a presumption of innocence until proven guilty, and not every case that gets filed has merit.
Let me ask you a question. Quick question, Judge.
And I want to get back to the show.
And then, of course, I mean, you got 40 minutes ago. With this guy Avenatti, after he took on Trump and the Stormy Daniels thing and all this, then afterwards, sexual assault. He was accused of sexual assault, went to jail, got arrested for that. And now this, and then there was another sort of a lawsuit against him. Do you think the big wheels are turning to nail him?
I don't know about the big wheels, but if it is true what they allege in a federal complaint, if it's true, and they got him on tape, I think that's a big problem.
They got him on tape talking about this?
They got him on tape.
What a dope. You would think that this guy would know better than that.
I'm not so sure about that. People do lots of things. Did you see Anthony Pellicano was just released from prison?
I did see that.
He did 10 years.
Yeah, I saw that.
He did some nasty things. I know because I had a case involving him, and he did some nasty things. So
not a nice guy.
Did 10 years.
Yeah, there you go.
So, there's justice.
Yeah, there is.
Anyway,
justice.
Let's talk about defamation.
All right, defamation.
Free speech.
Free speech.
Somebody says nasty things about you.
Oh, I just hit him.
What do you do about it?
I hit him.
Oh, that's me. You're a terrible example.
Sorry.
I can't use you for an example. Then who's going to defend you for the assault and battery? No, but seriously.
Yeah, where's my dad when I need him?
Well, the problem... But your dad was a criminal lawyer, so...
Well, an assault charge is criminal.
It's also civil.
I got to say one thing. My dad never, ever had to represent me on anything.
That's because you went to other friends.
No, I never got in trouble when he was around.
When he was around. You threw that little zinger in at the end of it.
I haven't
when he
been
was
in
around.
Trouble. All right, we got to take a break.
We're going to talk about defamation right after the break.
All right, it is For the People, Judge Herb Dodell, and get his book From the Trench to the Bench, the revised edition, now available on Amazon.com.
1050 AM, KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, He has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, I decided to do defamation today because with the advent of social media and the dissemination, the easy dissemination of information, defamation is more prevalent today than it was before. Previously, you almost had to have a one-on-one where you said something. One of the conditions for an action for defamation is something called publication. And what I'm going to do is I'm going to use some legal words, but as I do traditionally, I'm going to explain what they mean in layman terms, so nobody's going to be misled by what I'm talking about. There really are two types of defamation. One is called libel, and the other is called slander. Most people don't know the difference.
Well, what is the difference?
Okay, I'm glad you asked. Libel is written, and slander is verbal.
Oh, okay. Did not know that.
Oh, and there's a very big difference. I'm going to talk to you about damages. You know, what kind of damage can you recover if somebody has literally defamed you? There's a difference between libel and slander in terms of proof.
Let me ask a question. Libel and slander, they're both the same thing, but one's written and one's, spoke?
Yeah, it's basically defamation applies to both.
Okay.
And what is defamation? What is defamatory?
Yes.
It's anything that holds a person up to scorn or ridicule or affects their business. A lot of it affects economics. For example, I was thinking of something to use as an illustration. Let's say you're an actor and you were offered a role in a film. It was going to start shooting April the 1st, and you were going to get $25,000. And somebody defamed you, and the studio pulls out. You have a duty under the law to do what's called mitigation. Mitigation means you have an obligation to try to reduce your damages. So you go out and you try to find something for April 1st, because that's when you're going to be working, and you can't. And you lose the gig. It's not rescheduled, and you lost $25,000. Is that recoverable? The answer is yes. It's recoverable if it's libel. Not necessarily recoverable if it's slander. You'd have to prove it to collect money under slander theory. Libel is what's called per se. There's a concept called libel per se. The word per se, P-E-R, next word S-E, means it's itself. So if you've got a statement that was made by somebody that basically on its face impugns your integrity, accuses you of a crime, it has to be a fact. Defamation relies on fact, only fact. And there are 4 different criteria that you need to prove in a defamation case.
So if somebody says something about you and it's a fact, it's okay.
Oh no, it's not okay if it's untrue.
No, I'm saying if it's true. No, if it's true. If it's
true,
that's what I'm saying. It's a fact that's true.
No defamation.
No defamation, but it's a fact that's false, accusing you of something like rape or stealing something or, attempted murder, whatever it may be.
Anything that impugns your reputation.
Right.
Mainly reputation.
A false statement.
Has to be false.
Right. But if it's true, it's not defamation.
But some statements are on their face. That's what the per se means. On its face are defamatory. You don't have to prove that they're defamatory because it's so obvious that it is, that it's per se. And in that case, you can recover damages a little easier because it's per se. Per se doesn't necessarily apply to a slander because it's a different standard. Because if you look at it logically, it makes sense. If it's libel and it's written, you got a document. You got something in front of you that you could see.
Right.
Otherwise, it becomes an issue of fact or an issue of proof. Did the person really say? Did the person really do? Or are there any witnesses?
Right.
And now using social media, that's libel. Even though it's not a physical, necessarily written, it's the equivalent of something that's in writing. And so that's considered to be libelous.
A lot of this is going on, too, with social media.
And you know what? One really bad comment, and you're done. You're done.
Yeah.
In fact, to get back to the situation with the guy Avenatti today, the other guy, they've said that about him. What if it's not true? He lost his gig. He's done with CNN. They took him off.
They fired him.
Fired him.
Really?
No proof yet, but enough. And I'll get into the Times versus Sullivan, the Sullivan versus the Times.
Don't you think
shortly.
that Garagos we're talking about could sue CNN for firing him if there wasn't proof of it?
I don't know what his arrangement is with the network.
They probably have some sort of.
They have enforcement. They have a morals clause in all of these agreements, I'm sure.
But still, if there's no truth to the matter and he loses his gig, is that defamation?
What happens is generally people try to get their gigs back, and as you see, it turned out not to be true. That's what we're looking at right now in Washington.
What a mess!
Turns out not to be true. So the bottom line is, the truth is a defense to a defamation action. If it turns out what you said was true, that doesn't eliminate the possibility that it couldn't be the intentional infliction of emotional distress, which is a different tort. These are torts. Remember we talked, a tort is a civil wrong as opposed to a criminal wrong.
Right.
And so you don't go to jail for making defamatory statements about people, but you can get sued and you can get whacked. Because some people lose a lot of money now.
You're not talking about the mob when you say whacked. You're saying whacked as far as money goes.
Yes.
Just to clarify, Judge.
But you're right. You know, those years when I was representing the guys with the crooked noses, I hear all these terms. I guess I absorbed them. You know.
You're gonna get whacked.
But you're right. That's exactly what they said.
Well, of course they do.
But how would I know, right? Because guys used to say that.
You used to work with them. That's why you know. That's why.
It was an interesting part of my life, if you really want to know.
That's pretty cool.
Anyway, the bottom line is the truth is a defense. But the problem today is one statement over the internet can reach millions of people. And how do you prove your damages, really? You don't know how many people that heard it. You don't know any of those issues. But publication is there because you know the event took place. So it's only a question of damage and who can you recover it from. There's legislation that was put into effect by the search engines and those companies to insulate them from liability. You can't sue them, even though they are the intermediary between the statement.
Oh, really?
They cannot stay have immunity.
Wow.
Yeah. So the question is, how vigilant are they going to be to keep stuff off that shouldn't get on? Generally, if it's not pornographic or something so insightful, I don't mean insightful meaning thinking ahead, then it ain't going to happen.
Well, look with Russia.
Yeah, well, that's part of it.
And all that.
But the problem is that today, one bad statement and your career is over. Oh, done. Somebody attributes something to you that you didn't do or didn't say, you're done.
So let me ask you a question, okay? Let's say you go on Facebook or Instagram or Twitter and you say something that isn't true about somebody, like you said, that's seen by millions of people. Can you sue that person for that statement?
Yes, you can.
How do you get a hold of them? How do you sue somebody that's in?
Well, you have to find them.
That's
obviously.
what I'm saying. I mean, they could be in,
well, they're generally
Luxembourg or somewhere.
Well, that's true. It'd be hard to get those guys. But the fact of the matter is that these are state court cases, defamation, and it's, by the way, is a 1-year statute of limitations in California, treated as any other tort. Not any other tort, but most torts are 1-year statutes of limitations in California. other than professional negligence against lawyers. That's a 2-year statute. The lawyers must have lobbied pretty good for that one. The fact of them, because it's 2 years. I take that back. It's 1 year for the lawyers. 2 years for general other torts, negligence. I had that backwards.
Mm-hmm.
But the bottom line really is the second defense is it's an opinion. If it's my opinion that I'm expressing, I think that was a horrible meal because it was well done or whatever you want to say about it. Your opinion is not actionable unless it forms the basis for another defamatory statement. But generally speaking,
let's say my meal. How about say my meal was terrible? It was overcooked, and there was cockroaches on there.
But you didn't pay extra for the cockroaches.
I'm just saying,
it's like that great joke. The food is awful, but the portions are too small.
Right, but you're defaming the restaurant.
Yes, you are. But if it's true that there were cockroaches there.
But how if there wasn't? That's defamation.
Oh yes, that's a killer.
Okay. All right.
Restaurants have closed over things like that.
That's what I'm saying. Because it's a Yelp thing,
yeah,
all this.
Absolutely. And there's not much you can do about it, although there is a kind of a quasi-cottage industry out there now that says that they can get all the negative stuff off of your off the internet.
Oh, yeah.
In other words, if you said a really bad thing and you have a restaurant, somebody said a really bad thing about the food or whatever it is, they say they can get rid of it. I don't believe that. I think what they can do is they can keep moving things above it so that
bury
on
it.
page 2 and page 3, people don't go to page 2 and 3.
They bury it.
So but I don't think, in fact, we talked about that during one of the shows we had about the defamation issue. So truth is a defense, an opinion is a defense. What about if you're famous? Is there anything special about when you're famous? It's harder to sue for defamation because you have to prove your actual damages. It's not an assumption that something has happened and you've been damaged economically. You have to prove it. It's the Times versus Sullivan versus the Times. New York Times is the landmark case on that subject. It says if you're a prominent government figure, it's very hard to come back with a defamation lawsuit. But it was even extended in a case called Gertz that said if you're even a public figure, don't even have to be a government figure. If you're a famous person like Gary Garver,
oh yeah,
it's harder for you to do anything because you're so famous.
Oh, I'm infamous, not famous.
I heard you were a legend in your own mind.
There you go. I'm not even that.
Well, I'm not sure about that. So there's 3 kinds of damages that you can get. One is called actual damages. That's for your provable economic loss. That's a business deal, lost profits, things of that nature, lost ability, capacity because you've been now besmirched. That's one element. The second is assumed damages. Like, if somebody says something really miserable and nasty about you, it's assumed that you suffered damages. And the court, actually it's the jury, in a jury trial, decides what your damages are. A lot of people come in and say they can't sleep at night, or they bring in doctor's letters and excuses, and you can sue in small claims court, by the way. You don't have to go through a full-blown, expensive lawsuit to do it, although if your damages are significant, sometimes you get it very, 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 very big numbers.
I should have sued Baldy, countersued him, because I couldn't sleep for like a month. I didn't know I could do that.
I don't think you really had a great case against Baldy.
No, well, he didn't have a great case against me either, so there you go.
And the reality was there's something in California called an anti-SLAPP, S-L-A-P-P. If he was exercising his rights by filing a lawsuit against you, then that's...
then I can't sue him.
That would be protected under this anti-SLAPP statute, which are often used. So right after the... break, we're going to play the
actual court case.
8-minute actual case.
All right, you got to set it up. You got to set up the case too.
But I must admit, of course, I'll explain what the case is about. I have to admit that I'm not sure about one of the facts. I'm going to have to wait to hear it myself. I haven't heard this. I heard it the first time, and I brought it into you, and you cut it down for me. So
I screwed up the decision.
The decision was absolutely right.
Okay.
Absolutely right.
Don't take it personal. We'll be back after this.
50 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
I don't know if anybody's ever done this before, but the tape really is public record. So there were people in the courtroom who heard all of this, so it's not like we're disclosing anything, and I certainly am not permitted ethically to comment on a case that's pending. This case is long since gone, so I can comment on what it is about. And obviously I need to give you a little information, you, the audience, so you know what the hell we're talking about. All right?
What help?
Well, as best as I can remember it. Because, you know, there was some days, I think I've told this before, but many of the people who are listening today hadn't heard the shows before. I had a day where I had 86 cases.
That's crazy.
I had 86 cases. I have 2 clerks in that court.
That's not even fair.
I was in Inglewood. Look, I took a reprimand years earlier when somebody said I give the people too much time. I said, no. I give them the time I need to hear the case and make a decision that's honorable.
Yeah.
I mean, I'm not going to just cut somebody off. This is a case where a lender had financed a car.
Okay.
Somebody had bought a car, and they were the financing company. And there obviously was an agreement that they paid the monthly fees and the interest and whatever, or they could repossess it. And so the owner of the vehicle got into an automobile accident and didn't make the payments. The car was taken to a tow auto place, and they did some work on it, and they certainly were pounding up the storage charges because they charge you by the day. And the lender wanted the car back. They didn't know how much damage there was, and it was a corporation, so they were limited to $5,000. Keeping that's a very important consideration. That's the most they could ever recover. And so there were several hearings before I got the case. I think I was the 4th judge that had this case. And the lender was there, and the auto body or auto whatever they were was not there. So what we do when a defendant is not present, this is the standard practice, is we hold what's called a prove-up. A prove-up is a basic, bare bones, tell me what your case is about, briefly, and I have to check to see whether the law precludes me from making a decision one way or the other. Sometimes they said, he breached a contract 4 years ago. If it was an oral contract, it's barred by the statute of limitations, which is 2 years in California. So you do cover some of the issues on these prove-ups, but nobody's there to complain. Nobody's there really to say it's not true. So the guy that was representing the lender, as you'll hear on the recording, had gone to law school. Hadn't passed the bar, but he had gone to law school, so he had some pretty good ideas. But it was a very interesting question. What should I do? Well, the body shop had the car, and the lender wanted it back. So what should I do? We're going to find out right now. We're going to play the actual case. This is the real deal. So go ahead, Gary.
All right, number 2, M&N Financing Corporation versus INA Auto Body LLC. A case ending in number 1054.
Morning, sir.
And you are the representative of M&N?
Correct. My name is Michael Prater.
I was just looking for that. I was just looking for that. I got the authorization here, okay. Last time there was somebody else appeared.
Correct, yes. Patty, Patricia.
Yeah, Patricia Lawrence.
Right.
Okay, it is now 9:47. No appearance by the defendant. I read this file. This is for a storage fee?
No, it's he wants storage fees, the defendant. We are a financing company.
Okay.
Our customer has not paid since October of 17. Allegedly, she got in an automobile accident. Took it to this auto body shop. It's been there since maybe January or February. We've been trying to get our car back. Insurance company can't get a hold of the customer. We can't get a hold of the customer. Supposedly, he took some parts off the vehicle. The car's just been sitting there. And so we want our vehicle back. There's a $14,300 balance.
Well, you know there's a maximum recovery in small claims
$5,000.
court anyway.
Right. That's what we're
You're a
asking.
corporation, so you're limited to $5,000.
And we're not going to collect the balance.
You want the car back?
That's what we're trying to inspect the vehicle, so we don't know if the vehicle's worth it. We don't know if the engine's blown or mechanical problems, major mechanical problems. It's a 2017 Mitsubishi Mirage. So,
Well, you know, most people don't know this, but you can have relief other than strictly for monetary amounts, you know. I could order them to return the car.
that's what we'd like.
If you did that, well, I have to check the complaint to see if you requested that relief. If you
Okay.
didn't, I can't add it.
Okay.
If you did, then I can.
I don't think she did. So can we
Let
dismiss?
me take a quick look at the complaint, at the claim. Why was it continued the last time?
Because we were trying to figure out if the vehicle was worth making some sort of arrangements with the auto body shop, but he won't let us inspect it.
He's not asking for anything, so you want,
The max. Yeah.
well, you want money,
Well, if you can
and then you
order,
don't get the car, you know.
that's what I'm saying. If you can order us the vehicle, if I could refile this,
Well, and what I can do is issue what's called a conditional judgment.
okay.
It's a technical thing. I can order him to return the car to you within 30 days, and if he doesn't, then you get the judgment for the full amount. That way, that's the best of both worlds for you.
I'll take that.
I would imagine so. My only concern is we're technicians, believe it or not. We follow the law to the maximum.
I went to law school,
Oh, you did?
and I had passed the bar exam. I'm working on it.
Okay, well, then you understand. I can only do what the parties request
Right.
unless I allow an amendment. And I don't think I can allow an amendment under these circumstances because you'd be asking for potentially more than what's in the claim. So it's limited to $5,000 in any case. I've done this before, by the way.
Okay.
When we're returning a property, if they don't return the property, you get the monetary judgment. You don't care about the car, you just want judgment.
I think
I'm just concerned that from a technical standpoint, they don't own the car, they're just holding on to the car. They're really they're just a bailee. And I don't know where you get monetary damages against the bailee since you're not a party to any agreement. You really are a third party. All right, what I'm going to do is I'm going to order them to return the car to you. And if they don't return the car within 30 days, they'll be obligated to pay you the amount of $5,000 because they are holding that car hostage.
Hostage, correct.
And that may be sufficient enough to give you standing to pursue an action for damages.
I personally tried to resolve it with these people.
Well, looking at it prospectively, if you got the car back and it's worth more than $5,000, you did better.
Exactly.
Uh,
Exactly.
and I'm not here to help you get more than you're supposed to get. But I'm limiting the recovery to $5,000 in the event of a non-return. So that probably protects you in both directions, and it gives the defendant, who's not here, at 950, an opportunity to return it without having to pay you anything.
Correct.
So you will no longer be hostage. And part of this court, for people who are still here, is to do justice. And this is called equitable relief, as opposed, you may remember that from law school.
It's been a while, but yeah.
Yeah, well, it's been a longer time for me. This way, the court is doing equity and doing the right thing. I think under these circumstances, this is a justifiable decision.
Yeah.
So you'll get your conditional judgment in the mail.
Conditional judgment. Okay.
We don't do that here, so you're gonna have to have a hearing to come back and see if they did return the vehicle.
Yeah, I'll tell you,
Okay.
I'll set it for,
And their judgment until.
I'm gonna be here August 28th. So what I'm gonna do is I'm gonna give him until August the 28th to do it.
Okay.
So I'll continue I'll set it for an order to show cause for that date,
Okay.
to see if whether or not it's performed or not.
Same time?
Same time, yeah. Does that work for you, Murray?
15 on 36.
Yes, so I'm gonna put down here, conditional judgment. Defendant to return vehicle or pay $5,000 to the plaintiff. OSC recompliance August 28th. This department, same time.
And I'll send those.
Yeah, well, court will give notice because it's a little more complicated than usual.
Thank you.
Okay,
Okay.
the defendant has a right to appeal when he gets to judgment, so if he thinks it's the wrong thing to do, I'm sure he'll let the court know. Okay?
Thank you, Judge.
Okay.
Okay, let's cut it. We'll talk about it for a couple minutes, and then we'll play what happened on August the 28th. Very short.
Yeah, that's interesting. Why didn't the auto body shop or whatever salvage place appear? What was their reasoning? Or did they ever give you a reason?
No reason. No appearance, no reason. And by the way, when I talk about an appeal, when you do not appear in small claims court and you've been properly served and all the technical requirements have been met, if you don't appear and a judgment is entered against you, it wasn't really entered at that moment, you do not have a right of appeal. You could argue later on you weren't properly served, things like that, and that's called a separate motion to vacate a judgment that's been entered. But that's not what was going on here. The reality was that they just didn't appear, so they didn't put up on any real defense. This was a very unique case in one respect, and I started to talk about it, and you heard it on the actual tape. All they could recover was $5,000.
Yeah,
right?
yeah.
Maybe not. Let's say the car was worth $15,000, and they gave him back the car.
Then they get more money.
They used the court. Yeah. They used the court to get more than the jurisdictional maximum.
Do you think the auto body shop or whatever was holding out and saying, "Hey, this is worth $10,000 and they can only get a judgment for $5,000"?
I don't know what they were thinking.
All right. Well,
I know one thing for sure. They didn't show up, so they didn't have anything to say.
and they didn't show up in the second time either.
Well, we're going to play that
All right,
one right after the break.
Okay, cool. It's for the people of Judge Herb Dodell. This is fascinating. This
Real
is,
case,
and
real
this is
live.
really. You have any more of these? These are really cool.
I didn't ask for any others.
We'll get some more.
NBC Talk Radio, 1050 AM, KCAA.
Did you ever meet a lawyer that was for the people? someone who had the best interests of the people at heart. Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
But I will say this is not Judge Judy. This is a real case. A lot of people think that what they see on Judge Judy and some of these other shows is real necessarily. A lot of it's dramatization. She can do a lot of things because those are not real cases. I can't.
Yeah.
I got to do it because it is a real case.
Right.
And I have to watch out for the rights of both parties. I was looking out for the rights of the defendant here, too.
Yeah. Well, I just want
to say legal interest. There's a very interesting legal issue here, which I didn't get into with them.
Yeah.
And that is the rights of a bailee. A bailee is a party. Let's say you go to the cleaners. You are called the bailor. You have brought your cleaning to the cleaners. They're called the bailee. They're in control and possession of your property.
Right.
It's temporary, generally. There are situations where a bailment it's called a bailment, can be a lot more complicated. But this party that owned the vehicle brought it to this tow body shop. What they created between them only, was a bailment. She or he owned the car, and the tow truck company or the salvage company or the body shop was the bailee.
Why wasn't the person that owned the car involved in any of this?
Couldn't find him. They
couldn't find them either.
Couldn't find him. Did you hear me say that they tried to find him and the insurance company tried to find him? Couldn't find him. So the question is, can a third party, like this lender, go after a party that's not in contract with them?
That's weird. Yeah.
Well, but they have a legal right. Their financing agreement provides ownership to them if there's a default.
Well, they should have gave him the car. I mean, they didn't
give him the car because they didn't get paid.
They didn't get paid by
anybody.
By the insurance company or anybody.
Right, nobody. They were probably out there trying to get their money. What surprised me was they didn't file a cross complaint, which you can do in small claims court for the amount of the storage and stuff like that. And then the argument would have been in reverse.
But wouldn't they have sued the person that owned the car?
But they couldn't find him.
That's weird. How could somebody just disappear?
It happens all the time.
Really?
Oh, sure.
People just disappear?
Sure. People are gone. Hasta la vista.
Wow.
The bottom line was you get a limited amount of time. We heard this case really lasted 8 minutes. We tried very hard. I had been talking about the 86 case day that I had. You can't spend a lot of time. But you could also see from this illustration how informal it could be mixed in with the formalities. You know, this was really an effort on my part to do what I thought was fair. What was right was right. I didn't care whether the lender was going to sell that car for more than the $5,000. It didn't matter to me. All he was going to get, the lender, was the $5,000. All he was going to get is a judgment for $5,000. It wasn't going to get no guarantee for the payment. So I set it for August the 28th, as you heard.
Mm-hmm. And
now we're going to play the very brief hearing on August the 28th.
Okay, here we go.
M&N Financing Corporation versus I&A Auto Body, and then I&A Auto Body versus M&N Financing Corporation. Anybody here for either of these cases? Is the defendant present or cross-defendant? Nobody's here? No one is here. We worked working this up. Okay. Well, this is the case I decided months ago. Are those other people there? I don't remember seeing the kid here before. Okay, Because they're not coming in, so I guess it doesn't much matter. Okay, with regard to these two matters, cases ending in number 1054 and 5001, there's no appearance by either party. It is now 11:36. The matter is dismissed without prejudice. Yeah. Let me see what decision I made. I think this was a compliance situation. Okay. I had ordered the plaintiffs to return the vehicle, sounds like a familiarity, or the $5,000 fee would be imposed. That was the decision that I think I made. I'm the fourth judge that's on this file. There are orders from 3 other judges. I heard this case on July the 10th. Defendants were ordered to return the vehicle to the plaintiff, or a judgment in the amount of $5,000 would be entered forthwith. Order to show cause scheduled for today. Compliance of conditional judgment is scheduled for today. Nobody here. So, I don't know whether they returned the vehicle or not. So judgment will be entered for $5,000. Pursuant to the minute order of July that I made that decision. With several appearances afterwards. Are there multiple defendants? Yes, there are. Yeah, I guess defendants jointly and severally. And that leaves us with number.
And that was it. The defendant had to return the car, not the plaintiff. The plaintiff didn't have to return the car. I misspoke there. The reality is I didn't realize it until just now, actually, that there was a cross complaint. They had filed a cross complaint against the plaintiff, which is basically it's like being sued. And so they were suing the plaintiff also.
But neither one of them showed up?
Neither one of them showed up.
That's weird.
Since I didn't know whether the car had been returned or not, I was faced with 2 choices. Whether I dismiss it without prejudice, which was my original decision, or I have to assume that it wasn't done because nobody showed up to tell me it was done. Normally when you have a situation like that, the party comes in and says, I gave him back the jewelry or whatever it is, and so there's no judgment entered. But I didn't know. And since I didn't know, I had to assume that there was a non-compliance because it was a compliance hearing. That's what it was called.
But they didn't show. But they didn't show up.
Nobody
Judge.
showed up. But apparently they showed up for something else in between. Maybe that was the filing of the cross complaint, because I made a comment that there had been other appearances made. I was the 4th judge that had this case.
Wow.
I don't know why, but it got to me at the end of the day. And so that was a real difficult decision to make technically. I really had to think of it. That's why I took it under submission, by the way, because I wasn't really sure when I heard it in July whether I would have to dismiss it if nobody showed, or whether or not I would enter judgment in case I didn't know.
And you didn't tell.
I didn't know.
Yeah, and you didn't tell the guy if you don't show up, case is going to be dismissed.
No, I didn't say that to anybody.
That's what I'm saying. You didn't tell. You didn't.
No, I didn't tell the
plaintiff
that.
Yeah.
No. That's one of the reasons I assumed that he had not gotten the car back.
Did you ever find out about this?
I have no idea. I have no clue. But it was kind of an interesting case. Look, I've had a lot of very interesting cases. I had a case that I took into submission also. Sorry I don't have that tape, though. That was kind of interesting. That was cancellation of a timeshare.
Oh, those
It was
are great.
a very interesting case.
I bet.
The promises that were made to the person who bought the timeshare turned out not to be very accurate, and they wanted their money back. But that person had bought 2 other timeshares, so they were familiar. They were real estate people. They were familiar with what was going on. So the question was, were they really falsely induced, or should they have known because
they've
been done in the past?
Yeah, they'd done it.
And I had the contract, and both parties appeared for that one, by the way.
Uh-huh.
That one I remember very well.
Can you get these?
Because
Can
I
you
got
get
a
these
type-
tapes?
I don't know. I don't think so.
You should get some of these tapes.
I don't think I can do that.
No? Oh,
No.
that's a bummer.
I don't want to mess around with the system
Okay.
because I don't.
It's fascinating, though.
This was certainly legal to do. I wouldn't do this if I thought it was improper. But court personnel are very pedantic and sometimes very overly technical. I just wouldn't want to be in a position where I'd have to explain that I was doing it because I have a show.
A radio show.
That might not work. Although I must tell you, the current presiding judge is a very nice woman. She's very, very flexible.
I just think it's very cool to hear. I mean, this is an actual court case, and people don't hear this stuff, and this is what goes down.
It's an absolute, and I didn't know I was going to do this. Obviously,
Mm-hmm.
I didn't know we were recording anything, and I didn't know that at some day this was going to be an issue someplace. This was just another one of the 20-some-odd cases that I got every day.
Wow.
And some of them are very, very interesting. And I've told so many great stories about, the guy with Casper the Ghost. For those of you who have never heard that show before, we had a water damage claim where the landlord wanted to get paid back the damages that the tenant supposedly caused, and the tenant wanted back the security deposit. That was the fight. We see those all the time, security deposit fights. And there's some very interesting technical rules about that subject, too. You should look it up, and we have it all identified in the book, for example. And so I said to the tenant, I said, there was gurgling water. How did what caused it? And he says, yeah, the house is haunted. I said, so you're blaming Casper the Ghost? I was going to go on with Ghostbusters, but I said to myself, one time I was told, don't use the courtroom for humor, Although I think there's a place for you.
Of course there is.
I really, absolutely. And I'm very flexible in the court. I'm not flexible about the cell phones. I take the cell phones away.
Yeah, please. No, I'm sick of cell phones.
If it rings, other than my phone.
It's rude.
If it rings, I have the bailiff take the phone.
It's disrespect.
Come back at 4 o'clock. You can pick up your phone.
4 o'clock?
Yeah, they have to come back at the end of the day.
Oh my God.
That's the penalty for letting it go off in the courtroom.
Lord.
Except mine went off one day. I said, what are we going to do about that? Here I am making this big speech, and my phone goes off.
Well, you're the judge.
That was a little bit of a different kind of approach today. And
that was cool.
I hope everybody enjoyed it. And we've got some interesting shows coming up. We try to change it every week.
I suggested to the judge, let's do a Facebook Live show next week where the listeners and people on Facebook Live can go on and ask you questions.
I'll do it. I'll even shave that.
You'll shave?
Yeah, because you're going to take pictures.
Oh, no, I'm gonna shave. I'm gonna have to shave. It's gonna be on me, not you.
No. You would look the same. I've had the mustache now for 50 years.
Don't be shaving. All right, please.
Okay, well, I'll come in au natural.
All right, please. Oh, yeah, don't do that either. All right,
Have a great day, Gary. You were wonderful. You played that tape without flaw.
Oh, geez. Well, thank you. After 25 years, I better be able to do that. It
was good. It worked out.
It was great. It was a great show, Judge.
Okay, we'll see you next week.
All right, and also get the Judge's book, From the Trench to the Bench, available on Amazon.com. It's a great book.
If you want to know about how the system really works, call me.
Yeah.
I got to ask Judge Herb at gmail.com, and maybe, it's a good chance, I'll respond.
Maybe.
Maybe. Definite maybe.
All right.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 106.